Good afternoon, everyone. Welcome to our 13th Fireside Chat on Transitions. We've been doing this since, I think, March 2021. So my name is Fiona Horsfall, as mentioned, and I'm the Director of OAR's Office of Research, Transition and Application, and you may know us better as ORTA. And at present, I'm also the Acting Director of the Technology Partnerships Office. And one of our roles is to provide transition support with the objective of accelerating transitions across NOAA and simplifying the transition process in general. And through TPO, it's looking at intellectual property protection and also tech transfer and the SBIR program. So our goal of these fireside chats on research transitions is to provide participants with a broader understanding of the transition of research and development at NOAA, and in this case, the intellectual property protection. And I want to thank the ORTA staff for pulling this event together. We have Katie and Alex online. This seminar will explore the disclosure process for inventions made by NOAA employees and detail how intellectual property protection fits into NOAA's research transitions. We call that R2X, and the pipeline. The session will be moderated by Mike Kruk. He's the Deputy of the Technology Partnership. And we will start with remarks from Parikha Solanki, the Senior Advisor in the Office of Patent Legal Administration at the US Patent and Trademark Office. We encourage you to ask questions through the Q&A chat box, as mentioned. Questions will be sent to Cassandra from the lower library, and she will pose those to the panelists in the second half of the event. If there's not enough time to answer all the questions, we will answer them directly via email with our panel of experts. Just as a note, on the ORTA website, we do have a feedback form, and we're collecting information on transition support, including a question on these fireside chats, to see how we can better serve our audience. Now it is my pleasure to welcome Parikha Solanki, the Senior Advisor at the Office of Patent and Legal Administration at USPTO. In this role, she advises internal and external stakeholders on all aspects of patent legal policy, with particular expertise in design and utility patents, prioritized examination, and restriction practice. Parikha has held previous roles as a special advisor to the director of the USPTO on cross-government matters and technology transfer, an intellectual property advisor, detailee to NOAA. So she was with us, I believe, in 2023. So you may have seen her there while she was with us, and a review specialist in the Office of Patent Quality Assurance and a patent examiner in the medical diagnostics area. Prior to joining the USPTO, she worked as a field engineer in pre-market clinical research in the medical device industry. Parikha has a BS in biomedical engineering and an MS in electrical engineering, both from Boston University. So welcome, Parikha, and we're glad to have you back, and the floor is yours.
Thank you so much, Fiona. I really appreciate that introduction. Good afternoon, everyone. I am Parikha, and I'm really happy to be joining you here today from our sister agency, the U.S. Patent and Trademark Office. As Fiona mentioned, I actually got my feet wet in tech transfer during my time detailing at NOAA within the Technology Partnerships Office. And my work there was really focused on helping the TPO team investigate and better understand the drivers and barriers to invention disclosure across the research workforce so that we could ultimately help the agency overall identify new opportunities to grow and maximize the public impact of NOAA's work and innovation. So I'm pretty excited to be back here and reconnecting with the TPO team and all of you to talk a little bit about intellectual property and how it shows up in the federal research ecosystem. So before I really get into the weeds of IP, actually, I'm not going to get into any weeds. Before I get into the nuts and bolts of IP specifically, I want to take a minute to explore kind of the interplay between federal research and public service. So research and innovation happens everywhere, right? It happens in the federal government, happens in academia, happens in the private sector. And the core processes and organizational drivers for it are usually common across all those sectors. But where we start to see differentiation is really in the researcher's mindset. Like, why are they showing up to do this work? And there's something really great and unique about federal researchers in that they're not showing up to do this work for fame or for personal gain or for bottom lines or sales targets. By and large, federal researchers are showing up because they really care about public service and they see their work as an act of public service. And I learned this, there's literature out there that documents this, but what really made an impact for me is the time that I spent interviewing NOAA researchers and scientists for this study with TPO. And while we collected a lot of practical information about what was going on, what really stayed with me, and I still think about it, is that clear passion that everybody had for doing some kind of good with the research that they were pursuing in the labs every day. So you guys collectively have a really clear passion for making a positive public impact. You're showing up to move the needle for everyone and really improve our collective quality of life. And I just continue to be impressed and really inspired by the dedication that NOAA's workforce brings to their work every day. So that's just a little bit about what we found in terms of why federal researchers choose this particular line of work. And in keeping with this topic of public service, it also happens to show up as an important theme when we look at the overarching drivers and foundations of federal tech transfer. So sometimes there can be this perception that patenting and licensing are bad ways of keeping advances away from the general public, of kind of like hiding the ball, so to speak. But in the federal government, this is actually not true at all. So the Stevenson-Weiler Act, which was passed in 1980, is the original legal framework for the tech transfer ecosystem we all work in today in the government. And it basically says that since federal research is funded by taxpayer money, we owe it to those taxpayers to provide them a return on their investment. So in other words, federal labs have a responsibility to translate their research advances back out to market so that the taxpayer can fully benefit from it. And that cycle of taxpayer dollars in to fund the research and then delivering the innovative outcomes of that research back out to market, that's the core of federal tech transfer and why we do this work, right? It's the process of adapting and delivering federal technology to solve the public's everyday problems. So here's where IP rights are going to intersect with federal tech transfer then, right? So tech transfer isn't a solo effort. The government alone can't complete that full journey of taking innovation from the lab all the way out to market. Like we aren't structured for manufacturing or product marketing, for example. There's all these parts of the journey that we don't do that kind of work. And so federal tech transfer really requires a concerted and collaborative approach between federal agencies, sometimes universities, and also private companies to get to that shared finish line of commercialization success for this important innovation. So when agencies like NOAA want to team up with private partners in this way for commercialization, there's a little bit of risk on both sides, right? If you don't protect NOAA's discoveries with IP rights like patents, then you leave them open and vulnerable to exploitation or maybe even like outright theft. So NOAA wants to make sure the integrity of the technical work is preserved and that the partner isn't going to sequester the idea away from the public in a way that limits its impact, because that's the opposite of what we're trying to do, right? We're trying to help the public. And at the same time, the industry partner needs to be reasonably assured that NOAA is going to do what they say they will and not give the technology away to someone else to develop it. And so when the technology is protected by something like a patent and it's shared through a license of that patent or another IP right, everyone can kind of just breathe a little easier and focus on the work of getting it out to market together, because now the terms of that partnership are clear to everyone and there are safeguards in place in both ways. There's also sometimes this myth that patenting will sequester knowledge in a way that runs counter to the values of science and research in general. There's this perception that research and findings should be open to everybody and openly accessible, and that if you try and protect it with an IP right, then you're doing the opposite. You're hiding it from people. But in reality, patenting and knowledge sharing are not mutually exclusive. They can actually be pretty complementary. So I don't want to go too deep into this one because I think we're going to get to it in the panel later. But just as an example, at the patent office, when you file a patent application, unless you make a special exception, we're automatically going to publish your application 18 months after you file it with us, right? So at that point, it's out in the universe as its own paper. It doesn't matter if it makes it to issue. Like, you've already got that knowledge shared out in the public in a way that anybody can grab it off the internet if they want to. And if the application proceeds to issue as a patent, then that patent also becomes its own publication that everybody can access. So when you protect your idea with a patent, you're actually contributing valuable information to the public body of knowledge in that area at least once, if not twice. And so patenting, we run on what we call like a quid pro quo system, is that we'll give you a patent to protect your idea in exchange for you agreeing to share information about what you've made to benefit the public at large. So I also want to share with you some ways that the general public benefits from federal technology. And some of the examples I'm about to give you, I really hope underscore the reality that, we might think of it in the abstract, but we're actually encountering federal technology in all parts of our everyday life. And one of my favorite stories comes out of the USDA. They have a lot of cool work going on there because they work in food and everybody needs to eat food, right? And one example that comes out of USDA is this problem of when you cut up an apple, it oxidizes and turns brown, and then nobody wants to eat it because it doesn't look good anymore. There's nothing wrong with it, but it's not visually appealing anymore. So a number of years ago, USDA partnered with a private company to develop and patent this coating for peeled apples that would keep them from browning for up to 3 weeks. And what ended up happening was that McDonald's picked up that technology and used it to add these apple dippers. Maybe they're called apple slices now, but now you can get apples out of McDonald's, right? They've added this to their menu. And from what I understand, McDonald's is now one of the largest purchasers of apples in America. So what this shows us is that not only did USDA help the public by getting a healthy snack into a fast food chain's menu, but this transfer of federal technology also resulted in our agricultural economy getting a boost. So, that's just one way that USDA has really, I think, leveraged their mission and their reach and their technology to really expand and amplify the impact of their work. Pretty much anytime you go to the grocery store, you're like surrounded by USDA innovation, which we wouldn't have if it wasn't for tech transfer, right? Another one that affects pretty much all of us is the cell phone camera. So it started at NASA's Jet Propulsion Laboratory as when a researcher was developing a CMOS sensor to try and achieve a lower power and more compact alternative to traditional CCD cameras for imaging when they go on space missions, right? When you're sending something out into space, like weight is really important and you want to make things lighter and as small as you can. And as he was developing this CMOS sensor, a light bulb went off and he was like, hey, this isn't just good for space stuff. It could also be used in a bunch of different ways here on Earth. And so early on in his innovation cycle, he partnered with, I think, the Tech Transfer Office at NASA, and they were able to think forward and jointly develop this plan for not only solving the problem for the NASA mission, but also developing it and identifying secondary applications that would help all of us who are not going to space anytime soon, right? And so what that looks like now is we all have this NASA satellite technology in our pockets or our purses baked into our cell phones. And that's what our cell phone cameras are using whenever we're taking a selfie or FaceTiming like your parents or whatever. That came from NASA federal tech transfer. And if it weren't for the federal tech transfer process, we might not have been able to take advantage of that. And I think it's interesting to consider what our lives might be like today if we didn't have those cell phone cameras, right? And I have one more example, which many of you might already be familiar with because it comes from NOAA, but I want to shine a light on it again because it presents a really interesting consideration when it comes to the different ways that patents can be used to protect an idea for maximum public impact. So this one is the lionfish trap. So Dr. Giddings developed this new and improved lionfish trap because they found that the existing ones were not being selective enough for the invasive lionfish, so they're capturing species they didn't want to. And also the lionfish were not really that excited and attracted to the existing traps, right? So he's trying to solve this problem of bringing more lionfish in and keeping everybody else out. And he worked with the Technology Partnerships Office to further develop and patent this technology to really solve this problem in a widespread way and make it available to the public, not necessarily through licensing though. So the way that, and I'll leave it to Derek and Jennifer to correct me if I got this wrong, but the way that you guys ended up using the patent to really maximize public benefit is that you kind of gave the technology away. So you patented it, but not with the expectation that you were going to go out and sue everybody else who was trying to make and use it. The patent is more of an insurance policy that if somebody tries to make and use a knockoff that's not working well in a way that could actually harm the ecosystem, then you have that property right that you can use to say, hey, this belongs to NOAA and you can't use it this way. But if other people want to make and use it exactly as you intended and it's working and achieving the mission that you went out to, you started with, then that's okay, right? So patenting isn't always about, sometimes it's about protecting your idea because you need to protect the revenue stream in order to further additional research and development. But there's also other ways that it can show up to really benefit the public that doesn't necessarily require a bunch of litigation, right? Anyway, so I know we're planning to do a deeper dive into a lot of these topics I just touched on at a high level with the rest of the panelists. So I'm going to go ahead and wind down my part here. But I hope I've been able to shed a little light on why intellectual property matters to all of us, no matter what area of the federal government that you're working in. And IP really is that bridge that connects federal research to the private sector and enables us to make a real difference. And so when we have strong and effective pathways for getting federal technology out into the marketplace, and when we work as a team to support this important work, we're not only improving the everyday life of the public, but we're also supporting our economy and creating jobs. So just to summarize, IP isn't necessarily about hiding a ball. It's more like making sure the ball gets into the right hands so that ultimately everybody can benefit from it. Okay, and that's all I have for now. Fiona, thank you again for giving me this chance to join you and your team today. And I will hand it back to you to get the panel going.
Great. Thank you so much for those remarks. And it's really fascinating. I was not familiar with the Apple example. I didn't know that was a USDA invention. I knew about, of course, the lion traps, but and the other one was the cell phone. So yeah, what would life be without our cell phones now and the cameras? So thank you so much. So right now, I want to just get on with things, and I would like to introduce Mike Kruk. Mike's going to, I mentioned earlier that he's the Deputy Director of TPO, but he's going to moderate this panel discussion. He directs NOAA's Small Business Innovation Research, probably you know it as the SBIR program, and NOAA's Technology Transfer programs that drive innovation and technology, fostering public-private partnerships and supporting small businesses and the US economy. Throughout Mike's tenure in NOAA, he has held multiple pivotal roles with NOAA, including leadership with NESDIS and OAR, and we're happy to have him here. He's overseen coastal climatology and drought recovery projects, spearheaded strategic planning efforts, and managed multi-million-dollar budgets while driving organizational efficiency. So we're really, really happy to have him here in TPO. His leadership now extends to fostering collaboration across NOAA labs, line offices, and external partners to align projects and outcomes with NOAA's mission priorities. So, Mike, I'm going to hand it over to you.
All right. Thank you, Fiona, and good afternoon. Good morning, everyone. Good to see you all here. That was a really kind introduction. I really appreciate that. And it's really a very honor to be the moderator for this esteemed panel we have here today. Let's introduce our panelists, shall we? Beginning with Dr. Ru-Shan Gao is a research physicist at the Cooperative Institute for Research in Environmental Sciences at the University of Colorado Boulder, working with the OAR Chemical Sciences Laboratory, where he previously served as a federal scientist for many years. We also have Derek Parks, who is NOAA's Technology Partnerships Office Commercialization and Business Analyst, and as well as Jennifer Stewart, who is TPO's Tech Transfer Program Manager. All right, so without further ado, let's dive right in. So the first question, I'm going to throw this to Parikha first, and then we'll go to Ru-Shan and then Jennifer. All right, so how do you navigate the balance between publishing findings for scientific advancement while also protecting intellectual property rights?
Thanks, Mike. So I'm going to go back to what I think I just touched on in my keynote, which is I don't think that it's like an either or question. I think you can do both. I think you can protect your technology while also sharing it with the public. And ideally, this can happen if you start thinking about the protection early on in your process. So that way you can put it in your planning, your work plan, and know like, hey, maybe I need to start a conversation with somebody else in my agency about whether I should protect this far in advance of any, like whether you're going to go publish a paper or go to a conference. So again, like the patent application, maybe people don't realize this, but there's a law that says you can't get a patent for something if you don't actually put enough detail into the patent to enable somebody else to make and use it too. We want your patent to become something that the public can use to really learn from and use it as a springboard to maybe develop further innovation. So in that way, I think that there's actually a nice intersection between protecting your ideas and providing it for greater knowledge and awareness, if that makes sense.
Very good. All right, Ru-Shan, same question to you. How do you navigate the balance between publishing your findings for scientific advancement and protecting IP?
Yes, so I agree. And the two things are not necessarily in conflict, in my opinion. The problem probably is the timing. And so I agree that if you have some ideas, the first thing to do is talk to people that who are the experts. So I'm pointing to Jennifer and Derek, and they will probably advise you to first file a tech. What is called a tech disclosure, and you fill this form, and then the ball starts rolling. But to me, the problem is not really the publishing and the protecting your IP. The problem is actually the time it takes you to do the first public disclosure and the two filing a patent. So I think for the federal agency, we have 1 year grace period that you disclose your research results, and you got 1 year to file the patent, and you probably could file a provisional patent first, so that will save you a lot of time and go from there. The trick is this, is that a lot of times you need to talk to people outside your organization to get the new ideas, to develop your ideas, to refine your ideas. And then if you disclose too much information to those people, that will start the clock ticking. And so I think there is some nuances there that Jennifer and Derek probably could help people try to manage that part. So that's my take.
Thank you, Ru-Shan. Great segue. Jennifer, you're next.
Yeah, I think we've already shared some really poignant remarks on this topic, and to Ru-Shan's point is our office will help you navigate that start and stop time from when you have a public disclosure versus an internal to NOAA disclosure, and assess whether filing a provisional patent application either in tandem with any kind of public disclosure you're having. So, for example, if you're writing a journal publication, we can have the invention disclosure come in at the same time as that, and we can have both efforts moving in parallel. If you have already published or publicly disclosed, then we can quickly file a provisional application, and that gives us that 1 year timeline to have that internal discernment posture to understand, should we patent? Just because we have an invention, we don't always doesn't always mean that should be patented. And so we'll assess the business case as to the value to America and the value to NOAA if we should proceed. And we help you navigate that timeline. And I will add that the individual scientists and laboratories aren't responsible for finding their own attorneys. You aren't responsible for paying any of the cost involved. We have intellectual property counsel that is provided to NOAA through NIST, and our office works with that intellectual property counsel on your behalf. so you don't have to learn new people and new processes. We can manage all of that for you, and we pay for all of the fees as well. And so I wanted to add that if you are preparing a scientific publication and you haven't yet disclosed it to our office, you can go to our website at techpartnerships.noaa.gov, and you can learn more about all of this, as well as get that disclosure form, that entry low lift disclosure form, which you already have all the information if you're preparing a publication. And in fact, the correlation between the information you've prepared for your publication and for the patent application are actually not very dissimilar. And so you've already done the work. You just need that little extra step of disclosing it to us, and then having us help you in the best way to move forward.
Thank you, Jennifer. That is well said. I often will be caught saying the government is here to help you, but it's true, right? We really are here to help and provide these protections. So, question number 2, we're going to pivot a little bit away from the IP perspective. Think about advice to those starting up, or to those researchers who are getting their feet wet with their newfangled methods, technologies, algorithms. What advice would you give to early career scientists about how they might go about protecting their IP while also fostering impactful collaborations? Parikha, let's start with you.
Okay, I'm actually just going to take it back. I don't know if you maybe you didn't want me to do this, but I would say I would direct you to go to your tech partnerships office or your ORTA. Like, those people are so smart and so experienced in how IP is going to show up for you, and they're wonderful guides to help you understand what you need to know in order to make sure that you're positioning yourself in a way to achieve whatever outcome you're looking for. And I say specifically what you need to know, because I know that when you're doing research, sometimes you're really focused in the science. You might be a little overwhelmed by all these concepts about like patenting and what does it mean and what do I need to do. And it can be a little bit of a relief to understand that you don't have to go all that stuff alone. Like, you have help. When you're in a federal agency, every single one has an ORTA or a TPO. They're different acronyms, but the same function. And they really are invaluable resources. So I would say maybe start off by just educating yourself generally on how patents work, so that you can keep it in the back of your mind as you plan, your research endeavors. And also take note that you have help, right? You've got somebody there whose job it is to sort of be your Sherpa and taking your ideas and holding their hands as you reach towards commercial success.
I love that analogy. So in TPO, we are blessed to have both Derek and Jennifer. I'm going to say Derek is our long-term Sherpa. And Derek, so the question now goes to you. What advice would you give to early career scientists on this?
Well, so thank you, Mike. I appreciate it. And one of the things I will kind of step back to let the young scientists know that's a common misconception, and actually our experienced scientists as well. But we do actually work for a higher level organization, which is the U.S. federal government. So when we talk about protecting your IP, it's less about your IP and more about protecting the government's rights in the IP. So when we sign up as employees of the federal government, one of the things that we give away is our right to the work that we're creating, the intellectual property that we're creating. In exchange for that, there are laws in place that allow us to benefit individually from that intellectual property. So that's one thing I would just keep in mind is, as a federal scientist or as a federal employee, period, the work that we're doing on a day-to-day basis, right, in using federal equipment and on federal time, does belong to the federal government. So that's one of the key reasons that we want to try to keep track of that a little bit more, is just to have a full accounting of what the federal government is producing, what NOAA is producing, and then we can start to make decisions based on that. So that would be one of my key takeaways for federal scientists, the new federal scientists, is just to make sure that you're disclosing those ideas early and often, as everybody has said. But then the other thing to note is we want to have good agreements in place when you start working with others, because the minute you start taking an idea outside of your lab and outside of talking with federal scientists and researchers, you're involving another organization, and another organization then starts to have rights to what happens from that point forward. So if you do that without having some sort of formal acknowledgement and description of the work that you're going to be doing and who owns what, then when it gets later on and you have a very complex set of software codes and some hardware that goes with it, and 10 or 15 different people have put their fingers in the work somewhere along the line, it gets very difficult to unravel who actually owns what piece of that intellectual property. And so, I think I'm going to be talking about that a little bit later on, but that is a critical step in what we do, is actually determining who owns what and who has rights to what, and therefore, as a scientist, how you can benefit from that intellectual property. So that's my long answer.
That's a great answer. Thank you for that. Jennifer, I want to go to you as well. Jennifer's been doing tech transfer for well over 20 years at this point. Certainly has some poignant advice to give to our early researchers. Jennifer.
Yes, absolutely. I'm all about doing more with less, and tech transfer is an enabler for that. There's many advantages to partnering with individuals outside of the agency. No one entity, private or public, can afford to hire all the experts in anything. It's just not possible. And so being open-minded to reach outside of NOAA and connect with small business, who are often very agile organizations or nonprofits, medium-sized and larger companies, faculty, other federal experts, you immediately expand your expertise with little to no additional cost to the taxpayer. It's just the smart thing to do if you want to achieve results faster, better, cheaper. And you can protect all the parties involved intellectual property by having the right fit agreements in place, like Derek mentioned. One of the most powerful and agile agreements we have in our toolbox is federal tech transfer professionals. And for you to make the most use of our CRADAs, Cooperative Research and Development Agreements. They're statutory created, agile, and nimble agreements that are established under 15 USC 3710A. And the NOAA TPO's Technology Partnership Office helps you every step of the way of establishing these relationships and getting the right agreements in place, such as a CRADA, maybe a non-disclosure agreement, maybe the patent license agreement or invention license agreement or software license agreement. And we put these all in place to empower your collaboration goals. And so as a new researcher to NOAA, I hope that you will take advantage of these tools to help us achieve more in that better, faster, cheaper framework.
All right. Thank you, Jennifer. That was great. All right. Let's move on to Ru-Shan, back to you. From your perspective as a scientist, what challenges and opportunities have you faced in ensuring your research outputs are broadly used and adequately protected?
Yeah. So what I would suggest is, well, again, one thing again is talking to TPO as early as you can, and if you have some ideas. But the other thing you might want to think when you do your research is often ask yourself, is there any commercial applications in your research? As a scientist, I suspect that many of us are more concentrated in science or in specific application in our organization. But really, we don't think very much about commercialization, and so that's something we really need to think about it. So give you one example is that we were developing that little instruments that we thought, and that's it's very useful, but I'm not sure if this really has any commercial applications. And then at that time, when Mackenzie, who used to be at the TPO, visited our lab, and so I was showing him around the lab and showing him that what we're doing, and he said, you really should patent this thing. And after talking to him, and I thought about it, I said, well, yeah, we probably should. And here's the reason. Even though this thing doesn't look, very high tech and it doesn't look very sophisticated, but if it's successful, that we want to use it in many, many occasions, and we want hundreds of copies of this instrument. And so the question is, do we really want to build those instruments ourselves? Or do we want to license this technology to a company, and so they can produce this thing, and then we can buy them from this company? And thought about, when we start to think about that way, and then patenting makes a lot of sense. And so anyways, that's a suggestion to people, is to think, many different ways and how those technology could be used. So this is my 2 cents.
Yeah, thank you, Ru-Shan. That was very helpful. I also think it's worth mentioning, back to the idea of invention disclosures. There's an executive order that has been around for more than 50 years, maybe even 70 years. 10096, that's your new, it's my favorite number now, which requires all federal employees to disclose anything that they invent while on the job. So Derek pointed out, if you're using government equipment, you're on government time, Executive Order 10096 says you need to disclose that. So Ru-Shan did exactly that. And the royalties from licensing, right, benefit not just the organization, but also the individual. So there's many ultimate benefits other than your own personal benefits, but also going back to the public, which is what our primary goal is. All right, next question, Parikha, back to you. From your perspective in USPTO, what are any emerging challenges or opportunities you might see coming down the line with respect to managing IP in the federal labs?
Thank you. This is actually a really timely question, because we're working right now on a study with NASA where we are actually going out and talking to tech transfer groups across the federal government to really understand what do you all have in common? What information can you share to kind of collectively help each other? And in what areas is everybody just going to naturally diverge and need to do their own thing? And I will say one theme that has definitely come up across the board is the challenge of raising and maintaining awareness about intellectual property across the organization. So, we were talking a lot today about the importance of researchers understanding the interplay between IP and their work in the lab, but everybody kind of needs to be aware of it in order to make sure you're all sort of collectively using it in the way that your mission defines it. And so one example is, like, maybe you might also need to tell your comms people about intellectual property and what to look for, because there's a chance that maybe the researcher might not know that they're supposed to go to TPO first. So maybe they'll go say, like, hey, I'm about to do this presentation. Do you guys want to do a social media post about it? And if the comms people know that, like, oh, that sounds like something that you maybe should talk to TPO about first, they can kind of help collectively shift the focus and direction of that work to make sure that you're not missing an opportunity there. So what I'm noticing is that a lot of agencies that are managing this really well are doing it through like a very multifaceted approach. So you have one type of IP training that's provided to people at onboarding. You have refresher training for people like in the middle of their career. You have like these just-in-time flyers that get posted up in the lab. You're going to staff meetings. So it requires like approaching it from multiple angles, but also being mindful that you kind of need to remind people, not just teach them up front, but continue reminding them that it's part of everybody's everyday work and you got to keep it in mind. So I would say that's probably like the most common theme that we've seen so far across the federal government.
Yeah, thanks, Parikha. I think just to add to that, my own perspective, the opportunity here for invention disclosures and managing IP in the labs, you can really draw down to a national security issue as well. Right? We don't want a government IP falling into the hands of any of our adversaries. So it is in everyone's best interest to come out to TPO, figure out how we can help you and support you, work with your invention disclosure, and get everything set up, not just to protect the government interests, but to make sure that everything that we develop goes back to the market. All right, I think we've got time for one more quick question. Let's go back to Derek and Jennifer. Derek, start with you. We talked a little bit about securing patents and negotiating some license agreements. Any lessons learned that you want to pass on along the way?
So I've got a ton of lessons. A lot of them are hard earned, and not necessarily relevant to everybody that's on the call. But one of the things that I will kind of expand on that actually I think Joe has asked a question in our list there, and that is that the importance of having an agreement up front when you start working with companies is really critical, and that just carries through everything that we do in tech transfer. There's a lot of tendency to do collegial work with folks in private industry, and that's fantastic. That's what we're really all about, is we want to be doing collegial work together with industry, because as Jennifer said, together the government and industry can make something that's better than we could do individually on our own. But in order to do that, and in order to really protect what you have, your intellectual property and your capabilities as a government scientist, we need to have some sort of an agreement with them. And through that agreement, we, the federal government, have rights to actually practice what comes out of that collaboration. And that practice is just a fancy word of saying that we can use it for government purposes. And if you don't have that agreement, you end up transferring a lot of your knowledge to non-federal partners in some way, shape, or form, and they can then just walk away with it. And maybe you're not doing that out of malice or lack of consideration. Maybe it's just a business decision, but you then, as the NOAA employee, are kind of left holding the bag. It's like, we spent 10 years working with you and now you're gone, or now you charge us twice as much for the technology that we helped develop. So with an agreement in place up front, and working with us to disclose anything that you have developed, any kind of intellectual property and technology you've developed, that gives you the leverage to be able to work with that company. They may still go off and they may get bought out, things may happen, but at least then as the government, we can retrench a little bit and put that technology out for others to develop for us for government purposes. So there's some nuances in there that I won't touch on right now, but that's the best thing that I can think of, is really just make sure you have an agreement in place before you start talking with folks outside the organization.
Yep, 100%. Don't be shy to come out and knock on our doors at TPO. We're here to help. Jennifer, you get the last word on lessons learned and IP.
Yeah. And as Derek said, many lessons learned and continue to learn. Tech transfer is both a science and art, and human engagement and human interaction mean it's very dynamic. I want to share a specific story from my time at the Navy, because I want it to be a little nugget of, plant a little seed of thought on in our scientists' minds about the value of intellectual capital exchange, intellectual asset exchange. This is a top lesson for me. I was new in the field of tech transfer. I had grown up in a Navy measurement science laboratory. And often we discussed in budget meetings the need to incorporate into our metrology software capabilities such as test uncertainty ratios and test accuracy ratios, TUR and TAR. And we just never had the budget. We'd request for funding to get this capability, and the funding never came. And so I had this little knowledge nugget in mind, and I carried it with me when I went into the field of tech transfer for the Navy. And this opportunity with a small business, a small metrology business, came up where they asked us and inquired, like, hey, Navy had developed this unique measurement capability software. We're interested in licensing that and creating a product for the commercial metrology marketplace. Would you be willing to license that for our field of use? And I asked them like about their capabilities and what software they already had. And in that conversation and in that sharing, they actually had developed Tur and TAR software. And so I entered into the conversation of Navy has this gap and we don't have a budget to fill that gap. This company has already developed this piece that we really need. What if we were to do a cross-licensing agreement where Navy granted them permission to use our software and they granted us permission to use theirs? How much money could we save the taxpayer in that process? And how much could we increase our capability for a budget item that we never seem to ever get the funding for? And so we happened to negotiate the Navy's first ever cross-licensing agreement. And what that really taught me is if you listen, and especially listen to those needs of both parties, both the NOAA research lab and the company's needs, and you're able to discern and identify the gaps on both sides, you can truly achieve amazing impact and cost savings to the taxpayer, cost savings to NOAA, and deliver really a remarkable, impactful solution that advances everybody's goals and creates that win-win outcome. And that is how I try to approach everything when I'm working with our scientists. I want to understand what is hard for you right now, and are there opportunities for us to partner with entities, be it through leveraging our intellectual property assets and our IP portfolio, be it leveraging your really specialized knowledge and expertise, be it leveraging NOAA's facilities and lab equipment and lab space to partner with industry to create these win-win outcomes.
All right, excellent. Thank you. So that takes us to the end of our prepared questions. Let's go to some audience questions. Cassandra, I believe you are standing by for assistance on that.
Yes, I am. Thank you very much. Audience, we have plenty of time to answer your questions. Please feel free to continue typing them in the Q&A chat, and I will upload them for our speakers to respond to. And for our first question, our tech team works closely with companies. We have had success, but also lost companies via buyouts. Good for them, bad for the government. How do we protect government IP early, for example, SBIR, and later with mature systems? NOAA adds value to companies, but often loses in the end.
I'm going to say Derek or Jennifer, you guys want to take a stab at that one?
Yeah, and that was actually, Mike, the question I was answering earlier. It's really critical to have that cooperative research and development agreement in place when you start working with companies and developing the ideas, because that gives you the leverage further on later on in the process. And then secondarily, disclosing your contributions to our office allows us to file and make determinations about who owns what upfront.
I'll add to that too, that the government, so as represented by NOAA in this case, always owns a paid in full right to practice our inventions, period. And so one aspect that's really important in your planning and in road mapping your technology and development goals is looking at the critical insertion points for both IP protection and partnership opportunities. And then us fully understanding from your communications and feedback from those partners, what is their market strategy and what does the market look like for them? And are their goals and priorities aligned with our goals and priorities? And where it's not, where can we negotiate terms in those agreements to help us continue to achieve our mission no matter what direction they take? And so I think with enough dialogue and conversation and communication, we can have plans in place to help with those stopgap measures and to address those things as they come. And we have the opportunity to find other partners. So just because one particular case or one particular company maybe didn't turn out to the results that you wanted doesn't mean that we shouldn't try again and that we shouldn't find another suitable partner. And we can help you with that. And we've been doing a lot more recently in like partner scouting, trying to find you like the right creative fit, the right partner fit. So happy to discuss this further offline too.
Yeah, one other thing I'll add in there that we have been doing in the past is we can put out a request for information for CRADA partners moving forward. So you can get interesting ideas coming in through the RFI process to see what companies are doing what and who might be interested. And that gives you a little bit better lay of the landscape.
Okay, Cassandra, next question. Keep the cards and letters coming.
Sounds good. So the next question is about the acronym, and I'm going to put real quick a link in the chat for the NOAA CRADA partnerships.
Yeah, it's not quite the right spelling. It's CRADA, which is Cooperative Research and Development Agreement, which is a living, breathing document that, in this case, the NOAA TPO will help you facilitate between typically another NOAA entity and either a private entity, academic institution, public health institution. There's a large variety of options. You may recall this summer on the NOAA.gov website, we highlighted a large CRADA with United Airlines and NOAA, one of the labs in Boulder, Colorado, so that they could perform studies of greenhouse gas concentrations on their aircraft. That was pretty cool. There is, as Cassandra noted there in the chat, there's a list of some of our CRADA partnerships that we currently have ongoing or have had. It is not a requirement for CRADA companies to want to be on this website. Sometimes you don't want to disclose that you are working with us. So it's not a bad thing. It's just that sometimes you have a trade secret that you just want to keep trade secrets, which is a form of IP.
I'll add to that too, Mike, is that the CRADA has language to protect both parties' intellectual property. And it is highly likely that inventions will result from your CRADA effort. And so we often will see or should see invention disclosures also come out of our CRADA partnerships because you have brilliant people coming together to solve problems. There's likely going to be new, novel, and creative solutions to those problems that will result. So the CRADA has all those intellectual property canned language, template language that NOAA uses in the CRADA Cooperative Research and Development Agreement.
Yep, and we are standing by ready to assist. We have lots of CRADAs. They're really a very powerful tool to use. Next question.
Okay, our next question is in the audience chat asking, can you comment on tech transfer as it applies to NOAA grantees?
Jennifer?
Yes. We certainly can comment on that. So our grantees, oftentimes, if we're referring to university grantees, cooperative institutes specifically, all universities that conduct research also have technology transfer offices. So Derek and I have counterparts in our research institutions that fall within academia, and we have relationships with many of them. Sometimes they'll get an invention disclosure from their personnel, and it might have a NOAA scientist listed on it. And we're like, we haven't received a disclosure from our NOAA scientists. And so we'll try to coordinate all of that. So first is oftentimes the grantees also have a tech transfer office. If it's an organization that doesn't have a tech transfer office, there are requirements under legislation called by DOL where they would report any inventions made by them, just like you would, to their employer. So the grantees would let their employer know that an invention was made and that they were named as an inventor on an invention, and they would have their own disclosure process. When it comes to inventorship is inventorship regardless of where the person sits. So if it's a project that NOAA is also a co-collaborator on, and we contributed to the intellectual property, our scientist should be named inventor, their scientist should be named an inventor. If your cousin Matilda contributed to the intellectual property, Matilda should also be named as an inventor. So inventorship has no boundaries in terms of organization. The next thing then we try to work through is determination of title, ownership, and rights, and who has rights to that invention and that IP. And so the university or the grantee may decide that they would like to take lead in pursuing commercialization, and they have rights in the invention, and that is a negotiation and agreement that our office enters into with that organization.
Jennifer, let's continue the CRADA piece. The question in the chat here is, if not all CRADAs are on the website, should we contact TPO directly to understand what CRADAs are in place?
Yes, if you're looking for examples that fit your specific scenario, we can talk with you about examples on those. Cooperative research and development agreements, CRADAs are not a one-size-fits-all. Because the legislation is very flexible, we actually have a variety of flavors of CRADAs that we enter into. And so our office can help guide you on which one to put in place. All you really need to know is what it is you want to do. I don't expect you to remember any of the legislation. I don't expect you to remember any of the policy or memorize anything. You are the scientist and you need to stay focused on your science. All I need to know is, and what our office needs to know is, what are you trying to achieve? And we will then help you put to the right tool and the right agreement and the right process in place. And so we can provide examples. If you're just curious, you can see what's online. We can give you more than what's online. But know that also there's a variety of flavors. For example, we have a standard CRADA. We have an umbrella CRADA. An umbrella CRADA allows you to set an overarching objective and research objective. But if you don't know what specific projects you want to execute yet, we can put that umbrella CRADA in place, and then we can execute project plans under that umbrella agreement. We also have limited purpose CRADAs, which allow you to do market research. Limited purpose CRADAs let you try before you buy. So you can actually kick the tires on a company solution and just provide them a report on how it performed, or vice versa. If a company wants to test one of our inventions, if let's say Ru-Shan here, his POPs invention, that is one of our successful examples of patent to commercialization. If a company wanted to test that hardware to see, is it of interest for them to commercialize it? They want to try it before they enter into an agreement. We would do a limited purpose CRADA that allows for that, or a commercial licensing agreement for that. So we have a way to tune the CRADAs to meet your needs. And so all you need to know is what it is you want to do. And if I ever tell you we absolutely cannot do that, then it really means we can't do it. We really try. We are an office of yes before we are an office of no. And so if you ever get me to a no, that really means legally we can't do something.
Excellent. Thank you, Jennifer. Cassandra, let's go to our next question.
Okay. Is there a program whereby I can make suggestions that are not directly related to my role in NOAA, but may still provide environmental protections for natural resources?
Parikha, is that something you can take a stab at?
I could probably take a stab at that. So there's not an official program that I'm aware of, and especially within our wheelhouse of technology transfer. The legislation for the tech transfer agreements that we entered into say that it must be within the mission responsibility of NOAA. So the topic of the CRADA, any kind of agreements that we're into first must follow within NOAA's mission. So if it's outside of NOAA's mission, I'm not familiar with any program. If it's within NOAA's mission, but maybe it's not something you are particularly responsible for or tasked with, then I would advise that you work with your leadership and your management to talk about your ideas and like how you can contribute. And a CRADA or an MOU or an MOA might be the right vehicle with their guidance and permission to enter into, to exchange your ideas and information and collaborate with others outside of the agency.
Parikha, do you have any thoughts on that one?
No, I was actually just going to defer to Jennifer's expertise.
Okay.
It's going to be a really agency-specific determination.
Got it. Okay. I wasn't sure if there was a PTO program.
I wish I had an easy answer, but I appreciate that Jennifer jumped in and took that one.
All right. All right. Cassandra, next question, please.
Okay. Our next question, what happens if NOAA makes a grant to a university, no NOAA scientist involved, and the grant results in an invention? Does NOAA have any ownership/credit?
Jennifer.
Yes, so we will always own a paid in full right to practice any inventions that are funded by US taxpayer dollars. Credit can look like a lot of different things to a lot of different people. And the university has first right of refusal to take title to the invention and to practice the invention or pursue commercialization based on their contract agreements under by Dole. So, Derek, would you, in terms of like credit, like how may we position credit to NOAA, maybe through a comms story or something like that, where we can share what our grantee performed and NOAA's role and maybe helping make that successful, if it maybe is just through the grant issuance. But do you have any other ideas that you could add there, Derek?
Yeah, not specifically. That pretty much covers it. Generally, with the grants, there is no stipulation on the part of the grant recipient for returning something back to us other than just the final report that was required under the grant. As Jennifer was saying, there is a chance if they develop new intellectual property as part of this grant, that they may choose not to pursue it, and we as a federal agency could request that they return that intellectual property to us, and then we could pursue it. In most cases, however, the university has done their due diligence and they've determined that there isn't a great deal of private sector interest or commercial interest in the product, and that's why they're not pursuing it. So it would be kind of rare that NOAA would pursue that. There is another option. Well, actually, that wouldn't apply for this one, so I'm not going to confuse that by going into that. So
I wanted to add one more thing that just came to mind is all federal agencies own a paid in full right to practice inventions made by them for their mission purpose. That means that we can enter into interagency intellectual property sharing agreements with other agencies to make use of their inventions as well, and vice versa. So like an example I have at Navy is, again, back to software, we were looking for a specific natural language processing capability. And we found that through publications that NSA had a unique software capability that could maybe solve our problem. We entered into an intellectual property sharing agreement with them. We already own that paid in full right to practice, but it's courteous to ask one another and to partner with our fellow agencies on making use of their inventions. And so that opens up a whole nother portfolio of IP that you actually have access to achieve your NOAA mission. So that paid in full right to practice applies across all agency boundaries.
Okay, Cassandra, we have another question ready?
Let me take a look. It does look like we have several questions that are all sort of about the same topic regarding the SBIR process. I'm seeing if I can summarize them all, since they're all about that process. Talking about an introductory CRA DA education piece is that there's something that the NOAA SBIR office could include going forward, as most PIs are not versed in private-public agreements.
Okay, so yeah, this is essentially what support can we provide NOAA SBIR awardees about CRADA education?
Yeah, so let me start with 6 years ago, the law was changed to allow for federal agencies to enter into CRADAs with SBIR awardees. Prior to that, there was a freeze on us having the ability to enter into a CRADA that involved SBIR funding. We can now do that, and the technology transfer side of the office that I manage is working with our SBIR side of the office program manager on having us provide this CRADA 101 to our awardees so that they are aware that they can enter into CRADA relationships with any agency. You can have a NOAA SBIR and have a CRADA with Army. You can have a USDA SBIR and have a CRADA with NOAA. So, and the difference of flavor of CRADA is there is a CRADA flavor called SBIR CRADA. And what an SBIR CRADA does is it takes into consideration the data rights and intellectual property rights that are afforded to SBIR awardees and have those rights become the leading rights in the CRADA relationship. So I think I agree with you that scientists and others are not well versed in the law and private-public partnership agreements. We don't want you to spend your time doing that. We want you to spend your time doing the science. And if there is a SBIR awardee that you're interested in working with, we can put that agreement in place for you.
Okay, excellent. Thank you for that. Last questions. We're almost out of time.
Okay, our last question. Can NOAA get royalties as a result of an invention? If so, where does the funding go?
So we have lots of folks here who could answer that. Short answer is, of course.
Show me the money. Show me the money. No. Yes, so the legislation states that royalties, which are negotiated by the Tech Transfer Office with the company, come back to the laboratory where the invention was made and to the inventors of that invention. The royalty payments will follow those inventors beyond employment at NOAA to wherever they happen to go, as long as that licensing agreement and the royalty terms are paying. The funding will follow that inventor actually all the way until their estate. This is why we ask for your home address if you ever depart NOAA and move on to another agency. We need to remain in contact with you so that we can make sure that you receive those payments, and upon your passing, that those payments would go to your estate. And so the funding or the payments that come in from royalties come to both NOAA as an agency. The legislation outlines what specific things NOAA can spend that money on, and then separately to the individual inventors. And it also comes back to all named inventors. So if we had a joint patent with a university, our office would work with our counterparts at that university on royalty distribution and percentages and how much should go to the university faculty and how much should come to NOAA. And so we negotiate and handle all of that.
Excellent. Okay, with that is our last audience question. Cassandra, back to you.
Thank you very much. I'm going to hand things over back to Fiona to close out today's seminar.
Great. Thank you so much, Cassandra. This has just been incredible. I'm looking at the comments coming in, and I think some of the questions have been absolutely fantastic and really helping explain a lot about IP, patents, and creators, and some information on SBIR. So, and I noticed that Becky said really learned a lot. So, really appreciate that. And I want to offer my sincere thanks to Parikha and Mike and to all the panelists for participating in this chat, because it's obviously been very valuable to the audience as well. I want to just let everybody know that you're welcome to reach out to ORTA, which includes TPO, of course, for any IP-related follow-up questions. Just go ahead and shoot an email to one of us, or there will be on the website, there's an email that will get sorted as well. I want to remind you that there's a link to the fireside chat will be available on the library YouTube channel. And I think within a couple of days, it'll actually be posted on the ORTA website as well. We are trying to run these every quarter, so please stay tuned for more details on our next fireside chat. Clearly, this is a topic that's of great interest, so we may revisit it again in the near future. I also want to mention about our SBIR program. We're looking for reviewers of proposals. The proposals that we get in, we have to have 3 reviewers at least per proposal. And whether you're inside NOAA or outside NOAA, we can use your help with those. If you want to sign up for it, you can go to the ORTA website, orta.research.noaa.gov, and there's a red button halfway down the page on the left. And I'll ask Cassandra to share that website in the chat here. So thanks again to all the panelists and to the audience. You have put forward some great questions, and we will be recording those as well and taking note of them. So with that, I'm going to hand it back to Cassandra for the final word.
All right. Thank you, Fiona. Thank you, Mike. Thank you to all of our panelists today. And thank you to our audience for joining us for today's seminar. We hope to see you at our next Research Transitions Fireside Chat. Have a great rest of your day.